Assalamualaikum and a very good day I bid to our respected lecturer, Professor Madya Dr. Tuku Intan Mainura binti Tunku Makmar. My name is Maizatul Akasha binti Mir Mafiz. Today, my group mates Amir, Shafira, Myra and I are going to talk about the doctrine of judicial precedent, specifically the application of judicial precedent in Malaysia, and also the circumstances of when a court may depart from a previous decision. Before moving further into our topic for today, let me give out the definition of judicial precedent. So, what is judicial precedent? A judicial precedent can be defined as a legal case that establishes a concept or a rule that a court or other judicial body will use in future cases with comparable issues or facts. In the same manner, the concept of judicial precedent also refers to the doctrine of stare decisis, which means to stand by things previously decided, whereas the material facts are the same. As a general preview, the Federal Court, which is Malaysia's top court, is bound by a previous ruling in a case with similar fact pattern. The Federal Court's decision is binding on subordinate courts such as the Court of Appeal, the High Court, and also the Magistrate Court. If the lower courts do not follow this binding precedent concept, in this instance, the judge will fail in his or her duties. In regards, when conducting a trial, the court must follow the legal procedures and legislation. So, how about in Malaysia? In Malaysia, there are two ways of application of this doctrine, which is vertically and also horizontally.
Hello everyone, now it is my turn to explain about vertical operation. Vertical operation indicates that the higher or superior courts binds all lower courts to obey it and to follow its past rulings. In sequence, decision of the Federal Court bind all courts by operation of the civil courts. The Federal Court's judgment bind the Court of Appeal, but the two High Courts of Malaya, Sabah and Sarawak, as well as subordinate courts are bound by the Court of Appeal's decision. The rulings of the Federal Court and the Court of Appeals bind the Supreme Court. The High Court's judgment are binding on the lower courts, but lower court decisions are not. All courts in the hierarchy must obey earlier decisions of higher courts, and they cannot refuse to do so on the grounds that they are incorrect, outdated, or delivered per inquiry of ignorance and faulty reasoning. For example, in the case of Hari Solid State and Bruno Gente Pereira in 1996, the Appellant's Counsel argued before the Court of Appeal that the Federal Court's majority ruling in Ramachandra and Industrial Court of Malaysia and another in 1997 was incorrect and should not be followed. The Court of Appeal disagreed with the argument that the court is obligated to adopt the preceding decisions of the Federal Court, even it is flawed, but it was an apex court decision that established a binding precedent.
Next, the second application of doctrine of judicial precedent in Malaysia is the horizontal operation. It means a court is bound to follow its own prior decision and prior decision of a court of the same level, whether past or present. However, the horizontal operation of the doctrine in Malaysia is more complex and bewildering compared to its vertical operation. Therefore, there are three phases that need to be looked at. Firstly, it involves Federal Court. In civil matters, the Federal Court does not regard itself bound by the decision of Supreme Court. This can be seen in Malaysia National Insurance, Sdn Bhd against Lim Tiok 1997, Volume 2, Malay Law Journal, page 165. In this case, the Supreme Court had earlier decided this case, but the current issue was whether the Supreme Court decision should be reviewed or overruled. The Federal Court eventually reviewed the prior decision of the Supreme Court. The Federal Court decided that the decision was wrongly decided and should not be followed. In fact, the Federal Court of Malaysia overruled a decision of the Supreme Court. But in criminal matters, the Federal Court holds itself bound by the decision of the Supreme Court. In Tan Boon Kin against Public Prosecutor 1995, Volume 3, Malay Law Journal, page 514, the Federal Court was faced with the issue of standard of proof to be satisfied by the prosecution at the close of the prosecution's case in a non-jury trial section 180 of the Criminal Procedure Code Act 593. Therefore, the Federal Court unanimously held itself bound by the Supreme Court decision in Ku Hee Chang against Public Prosecutor and another, 1994, Volume 1, Malay Law Journal, page 265. Second, we will look at the Court of Appeal. Similarly, in the Court of Appeal, it is bound by their own decision. One case that could illustrate this is in the case of Syarikat Kayu Bersatu against OMW Sarawak, 1995. By doing so, the Court of Appeal has discarded the fact that it is bound by its own decision and decision of other court of coordinate jurisdiction. It is the matter that is related to the High Court. Under Article 112, Clause 1 of the Federal Constitution, there are two High Courts of equal jurisdiction and status, which are High Court of Malaya and High Court of Sabah and Sarawak. As far as the High Courts are concerned about the practice of horizontal judicial precedent, the attitude and assumption of a High Court judge of Malaysia is that a High Court judge is not bound by a decision made by another High Court judge either from the original or appellate jurisdiction. This was the position in the case of Ng Hoi Chu against Public Prosecutor, 1968, Volume 1, Malay Law Journal, page 53, where Justice Chang Mintat did not follow the decision of his contemporary Justice Min while exercising appellate jurisdiction. Also, in Georgina Singh against Public Prosecutor, 1984, Volume 2, Malay Law Journal, page 133, the High Court, while exercising appellate jurisdiction, ruled that it would not follow the decision of the High Court in an appeal presided over by 3 judges. The above practice of the High Court is observed to continue to exist unchanged under the Malaysian court system. And that is all from me. I'll pass to the next presenter, Shafira.
Lastly, there are situations where the doctrine of judicial precedent may not be applicable. In certain circumstances, the judge may choose not to apply precedent from previous cases. These exceptions were laid down in the case of Young and Bristol Airplane Company Limited, 1944, 1 Kingspan 718. The first circumstance is when there are two conflicting previous decisions, in which the Court of Appeal must decide which to follow and which to reject, regardless of whether the conflicting decision is an earlier or later case. The second circumstance is that the Court of Appeal must refuse to follow a decision of its own that cannot stand with a decision of the Federal Court, even if the decision has not been expressly overruled by the Federal Court. Lastly, when the Court of Appeal need not follow a decision of its own if satisfied that it was given per incurium. In criminal matters, however, because a person's liberty may be at stake, the Court of Appeal may also depart from its own previous decision if it is satisfied that the law has been misapplied or misunderstood in the previous decision. The position of the Court of Appeal in the criminal jurisdiction should also be different from the civil authority as derived from the judgment of Lord Diplock in Regina and Gold 1968 to Queensband 65. It was decided that in the criminal jurisdiction, the Court of Appeal does not apply the doctrine of stare decisis with the same rigidity as its civil jurisdiction.
From all of the explanation that we have shared today, we can come to a conclusion that the doctrine operates both ways, which is vertically and also horizontally. It works vertically when the court is bound by the prior decisions made by the higher court, and it also works in a horizontal way when the court is bound by its own previous decision. Last but not least, the court is not bound to follow its decision if it was per incurium. So that is all from our group today. Thank you so much for your time. Wabillahi taufiq wa hidayah. Wassalamualaikum warahmatullahi taala wabarakatuh.